studied them and I actually researched, but I'm glad that you've been working on it too. Mr. Schroll, please raise your right hand. Do you solemnly swear the testimony you're about to give will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, ma'am.
Sir, the attorneys have given me paperwork that suggests you have come to an agreement with the state resolving your case. Is that your understanding?
Yes, ma'am.
All right. The paperwork indicates that you are planning to plead guilty as charged, that you and the state have agreed that your sentence will be a 4-year sentence in the Tennessee Department of Corrections, that on each count that they will run concurrently, that you will be taxed with the court costs, you'll be on the sex offender registry, that you will have no contact with any of the victims in this case, no contact with any Bradley school function. You are banned from entering any Bradley County or city school facility, that you will have that psychosexual assessment, a pre-sentence investigative report will be prepared, and then we'll be scheduling a sentencing hearing where I will determine the manner of sentence. Is that the agreement you made with the state of Tennessee?
Yes, ma'am.
Let me tell you about your rights. Because you're accused of these crimes, the Constitution guarantees you the right to a speedy and public trial. In your case, the trial is scheduled for May the 1st of 2024. At a jury trial, or a trial to the bench or to a jury, the state of Tennessee would have the burden of proving that you committed each element of these crimes. They would have to prove those elements to a burden of beyond a reasonable doubt. You also would have the right to confront the witnesses against you. And if I look at the back of your indictment, the witnesses disclosed by the state are Bobby Ruth, Shane Clark, Corey Fox, Brett Taylor, Matt Landau, Jeffrey Humbird, Daniel Gibbs, John Mylan, Nat Acciona, and Scott Carroll. Additionally, based on the nature of the charges, I suspect that there would be some minor victims, L, M, and JB. So you would have a right to confront those persons, and your attorney could cross-examine them on your behalf. You also have a right to use the power in the process of the court to make the state show you the evidence to be used against you, or to make your witnesses come to a jury trial. At a jury trial, you could testify if you chose to do so. The Constitution guarantees you the right to remain silent. You also have the right to be represented by an attorney, and that attaches at all stages of the proceeding. Do you understand your rights?
Yes, ma'am.
Do you understand that if you enter a plea today, you will have given up your right to have a trial, so there won't be a trial of any kind on these charges?
Yes, ma'am.
Without a jury involved in that decision, you've also waived your right to let the jury set your fine. Do you waive that as well?
Yes, ma'am.
Any old convictions on your record can be used to determine the proper punishment on this case. Do you understand that?
Yes, ma'am.
Whenever someone enters a guilty plea, you give up your right to go to the Court of Criminal Appeals to complain about your arrest, search and seizure of your property, use of any statements you might have made, your right to counsel, your right to a speedy trial. Are you giving up those appeal rights?
Yes, ma'am.
And if I approve this agreement, then at the time of your sentencing hearing, judgments of conviction will enter. I don't know enough about you or your case to even guess what I might do in terms of your sentence. But because this crime carries up to 4 years on each case, and you have agreed to a 4 years concurrent, you're facing, as a worst case scenario, 4 years in the penitentiary to be served. You could receive some sort of a sentence of split confinement, which means time in the jail followed by release to community supervision with conditions, or a probated sentence. Do you understand that?
Yes, ma'am.
Those are the possibilities at a sentencing hearing.
Yes, ma'am.
After that sentencing hearing, you will be a convicted felon. The law says you are rendered infamous. That means you lose your right to vote, you lose your right to have or own a firearm of any kind. Your testimony could be attacked or impeached using the conviction, and these convictions will be on your permanent record, so if you ever get in trouble in the future, they could be used to increase the punishment you get on any new crimes you might commit. Do you understand the consequences that come with the choice you're making here today?
Yes, ma'am.
The law guarantees you the right to have a separate hearing where your sentence would be determined. And although you have an agreement that defines what the sentence will be, the manner of service is what will be determined at that sentencing hearing. So that I have full information, I'm going to order that a pre-sentence investigative report be prepared, and the attorneys and I were looking at the law, and there is 3913-705 that mandates you have a psychosexual assessment as a portion of the preparation for the sentencing hearing, so that I have the benefit of that information as well. At the sentencing hearing, a copy of the report will be provided to your attorney and to the state of Tennessee, as well as the court. We'll be able to study it 10 days before the hearing. You can bring in whatever witnesses you wish to have heard. The state can bring in whatever witnesses they want me to hear from. And it will be at the conclusion of that hearing that I determine the manner of serving your sentence. Do you have any questions about any of that?
No, ma'am.
Did you use any drugs or alcohol today?
No, ma'am.
Have you ever been treated for mental disease or defect?
No, ma'am.
Why are you hesitant?
I have a prescription for sertraline and divalproex now.
And is that something that treats a mental condition of sorts?
I think it's for bipolarity.
Okay. So whatever expert that you have consulted with and has given you this medication, does your condition that led to that treatment make you think you don't understand what's going on here today?
No, ma'am.
In your work with Ms. Henderson, have you had enough time so that all of your questions have been answered?
Yes, ma'am.
Did your attorney talk with you about the possible defenses you have to these allegations?
Yes, ma'am.
Do you have any complaints to make about the legal representation you have received?
No, ma'am.
Sir, your attorney gave me what I call these plea papers. Did you go over this document with Ms. Henderson?
Yes, ma'am.
And I see some writing, blue marks on this. Did you and she talk about this as you went through this?
Yes, ma'am.
And over here, on page 5, there's a signature.
Yes,
Is
ma'am.
that your signature?
That is my signature.
And did you sign this document to tell me you understand what you're doing and you have chosen to resolve your case this way?
Yes, ma'am.
Please listen to the facts as announced by the state. I'm going to need to hear the facts so that I can make a determination if I think this is a fair resolution. General.
Yes, sir. Thank you. You know, if this case goes to trial, the proof would be that on March 15th of 2022, investigation from the Cleveland Police Department responded to Cleveland Middle School in response to a camera that was found by a student in the girls' locker room. This was turned over to the school resource officer. It was a black Divine Eagle Spy camera, and it had a 200 had a SD card in it, and it looked like a phone charger. And it was plugged in, and this camera is motion activated, so when someone walks across it, it picks up a segment of video at that time. they were able to, this was turned over to Detective Landholt, the Cleveland Police Department. He was able to review 12 video clips taken on that day of March 15th of 2022. And it showed multiple juvenile females inside the girls' locker room changing. One female was taking off her shirt, and she had a sports bra under, and another female was changing pants within the, there was no, the reason it's an attempt, Your Honor, is there's no, all of them are in various stages of undress, but no one is ever in nude. So this was turned over at that time, and detective from the Cleveland Police Department started an investigation. They were able to view a security video from the Cleveland Middle School, which showed that on March 14th, that they observed the defendant was in the area of the girls' locker room around 7 a.m. that morning. And again on March 15th, which was the day the camera was discovered. When they went back, typically went back, he was able to also recover images, not videos, but images of the day before that was taken. And these are just still images of a video that was deleted. So on the SD card itself that was removed from the camera, Detective Landholt was able to recover these images, and it's the same classroom that's in there, and they're also changing on that day. So it's the Monday and Tuesday of that week. They brought the defendant into a conference room. The detective read his Miranda rights. He advised that, in fact, that was his camera. He purchased it from Amazon, and that he put it into the girls' locker room on that Monday morning, and advised that he did that because he was getting complaints from female students about bullying and harassment within the classroom. He stated he got the camera that day, and he'd take it home and review the footage on his desktop, which was stored at his residence. What's noted also in reviewing the camera is it doesn't record audio, which would, the state's position would that would be counter to his version of events of why he had it in the locker room. Also that law enforcement talked to the principal and about this, and stated that the defendant had never brought any allegations of bullying harassment to their attention. It was determined that he had brought the camera on Monday morning and took it back on Monday afternoon. He then brought it back on the Tuesday, the March 15th, the day it was discovered, and also put it in the girls' locker room, which was when it was discovered by a student. They, at that point, conducted a search warrant of the defendant's residence. They collected the computer. They collected several media devices in that, and searched all those, and nothing was uncovered about any additional images within those. However, on the SD card itself that was in the camera, there were, which these were introduced in the preliminary hearing, and also with the state's position would counter defendant's version that of the reason that he was doing this. There were other images, which we refer to as upskirt images, taken from 2021, and also, which was also introduced in the preliminary hearing, additional still images that used to be videos taken from a different camera in the year before from the locker room itself, which also in that there is someone changing. You cannot see any faces on any of these images, so that's law enforcement was never able to identify any of these individuals. Also, when they conducted that search warrant of his house, they found the user manual of the camera that was used on the 14th and 15th. And in his backpack, located at the time of his arrest, they found the box, a case for the SD card, and the power cord for the camera. It was the same classroom, Your Honor, on both dates. What the state, part of the agreement is for no contact with any of those individuals. What the state will do is provide the list is under seal to the court at the sentencing hearing, so the court is aware. We have been in contact with all these parents and investigators about this plea agreement.
And so all of the parents are supportive in resolving it this way?
Yes, Your Honor.
And is law enforcement satisfied with this resolution?
Yes, Your Honor.
And what about the school system?
We have also been in contact with them, and have, they have not said they were not in agreement with it, Your Honor. And it requires also that he is barred from those facilities and to have no contact with those functions.
So, Mr. Schroll, did you hear those facts?
I did.
Are those the true facts of your case?
Yes, ma'am.
So, to the allegation that you attempted aggravated unlawful photography of a minor on March 14, 2022, how do you plead?
Guilty.
And to the allegation that you committed that same crime on March 15 of 22, how do you plead?
Guilty.
And are you pleading guilty because you are guilty?
Yes, ma'am.
Mr. Schroll, I'm going to accept your plea. I make a finding that you know and understand what you're doing, that freely and voluntarily you've given up your rights. And based upon your acknowledgement of guilt, I make a finding of guilt on each of these cases. Consistent with the law, I am going to require that a pre-sentence investigative report be prepared. You'll be working with Ms. Henderson today to fill out the court order so that they can send you the packet of information that is required. Part and parcel with that, and consistent with the law in 3913-705, you must complete for sentencing a psychosexual evaluation. That report will be attached to the pre-sentence report and will be available for review by both your attorney of the state and the court. Have you all agreed on a sentencing date?
Your Honor, July 19th at 8:30, that's a Friday, according to your assistant. There are no other things currently scheduled.
I can't imagine a date with nothing
I know.
else scheduled, but maybe that means nothing being
Yet.
scheduled. July 19th
I would maybe block off the whole morning.
for this case.
8:30, yes, Your Honor.
All right. I do see, and I'm wondering if this is one of those cases, there is a Clayton Taylor scheduled for jury trial and a Jason Baker scheduled for jury trial on the Thursday before. Are those one-day cases, or did I intentionally keep July 19th light so that those cases could spill over onto Friday?
That Taylor case is mine, and I don't think it's a one-day trial. I think it's probably a day. You think it's a day and a half?
Your Honor, it's also my case. I would imagine it could be one long day or maybe a day and a half, like the general said, but I don't anticipate that case would settle prior to this.
Does Your Honor want to put it at 1:30 on Friday.
And just block off the afternoon for it?
Yes, sir. Yeah, that works.
All right. I'm going to make notes here that I'm just thinking that's why I kept that day light. And so this sentencing hearing will be 7/19/24 at 1:30, and your best estimate is 3 to 4 hours.
Yes, sir.
All right. So I'll schedule nothing else for that day. And that also means that as the department prepares the pre-sentence report, but that psychosexual evaluation, it is my understanding that there are only 2 experts in all of East Tennessee that these reports. And so if they cannot schedule an appointment and assure everyone that we'll have a report by the sentencing date, you'll need to notify me so that we can schedule a different.
I will do that, Your Honor. Allison Kennedy, a former prosecutor from the 9th who is now with our firm, should have the contact information for those individuals who are certified to do those evaluations, and hopefully that will expedite it. If there is a problem with getting something scheduled and completed prior to that date in sufficient time, I will notify the court and counsel for the state.
All right, good. Anything else that we need to take up today?
No, yeah, thank you.
All right. So we will need that pre-sentence investigative report order.
And Your Honor, I don't know where that,
They've got them over there somewhere.
okay. Mr. Schroll, if you will go, just come and do that.
Thank you.
Okay. All right, thank you.